So everybody can see the presentation. Thank you. So without further ado, I'm going to start the presentation tonight. Thank you so much to everybody. A hearty welcome to you, and thank you for joining Firzt as we have a discussion about what buyers need to be aware of. We are going to go through it in terms of a slideshow, and we are recording the session for your benefit should you not have listened to the entire presentation this evening. My name is Joanne Gray, and I'm the General Manager at Firzt Realty Company. I started my career in property in 2003, some 17 years ago, and I've been at Firzt Realty for 12 years now. You might be saying, why are we doing this presentation to discuss buyer beware? And the reason is that so many of us are not regular home buyers, and some of us are even first-time home buyers, and we're not used to seeing contracts and what offer to purchases are all about. So in terms of what we are dealing with, we have to be aware of the fact that buyers have to be beware because of South African law. Now, is Roman law a source of South African law? So when a specific matter is not governed by legislation, common law usually applies. South African common law is mainly the 17th and 18th century Roman Dutch law, which is what we're referring to, that was transplanted into the Cape. And this law forms the basis of modern South African law and has binding authority. Now, you might also want to know what does a contract need to have in order for it to be binding in South Africa. So just as a quick basis, I'm going to give you 3 points. The one is that a contract or an offer to purchase has to have consensus between the contracting parties. The second thing is their intentions with regards to the agreement must result in terms that can be enforced. The third thing is that the parties must have capacity to contract. This relates to an individual, whether you're an individual buyer, or a company, a closed corporation, or trusts, and you have to have the legal ability to enter into that agreement. So in terms of age, you have to be 18 or over. If you're younger than 18 years of age, you're considered to be a minor, and you need to be assisted by your parents or a guardian. So the last thing you want as a buyer, and just adding a bit of humor into the presentation, is to end up buying something that looks like this when your expectations were something else. So you have to be aware of what you need to look for. And it's the estate agent that you're dealing with's duty to make you aware of what to look for when considering to put in an offer to purchase, and to advise you on how to protect yourself. Reputable ethical agents will ensure that they have covered all the aspects of the property with the seller and obtained a beautiful disclosure document that Firzt has. The duty of the seller is to complete all known defects that are patent and visible to the eye on that disclosure form, as well as anything that is latent that they may be aware of. But latent defects are usually not known to the seller, and they themselves may not be roof engineers or foundation specialists. And only if there's a big crack in the wall that you can put your fist through will they suspect then that there's a latent defect relating to an issue with the foundations. So an astute estate agent will always get a disclosure document And in some rare instances where a property has perhaps been rented for a number of years with the owner living overseas, the agent will then inform the buyer that there is no disclosure document and that the Firzt clause is applicable. I will come to the Firzt clause and an example of the disclosure document further along in the presentation so that you can actually see what that looks like. Estate agents must always have a fidelity fund certificate in order to contract and earn their commission and their income. So you always have to make sure that you are dealing with a reputable estate agent who does have a valid fidelity fund certificate. These are some of the guidelines that we all base and hold dear to ourselves working at Firzt. At Firzt, we are very, very accountable. We have excellent ethics, astute principles, and you can know that when you're dealing with a Firzt agent, you have your best intentions are at heart and our integrity and values are in place. Firzt means that you're buying the property in the condition that you see it in. So as a buyer, you'll go to view the property with the estate agent at a given appointment, and you will take your time to peruse the property and ask the estate agent for various questions to give yourself peace of mind as to know what the details and extra finishes relate to in that property. If there is something in that property that perhaps looks like damp, as an example, and the seller has advised the estate agent that they're not prepared to fix the damp, it will be for the buyer's account. The estate agent will at that juncture tell the buyer that that's the situation regarding the damp. It's there for them to see and that it will be for them to fix as the buyer after transfer when they own the property. So in most real estate companies' offers, you will always see a Firzt clause. And a Firzt clause is a binding clause that says that you are buying the house in the condition that it stands in. It's up to you to discuss any issues that you see that are patent and glaring at you in the face to ensure that the fixing of those items or issues is dealt with in the offer to purchase. The estate agent again will guide you with that. A patent defect is something that you can see. It's not hidden and ought to be easily identified upon reasonable inspection of the property. For example, a hole in the carpet or a cracked window. You can easily see that, and you can ask the estate agent, is the seller going to fix that pane of glass? And they will advise you what the seller's intentions are and then record that in the offer. One thing, buyers, please, you can never have a discussion with an estate agent about various items that are untoward or wrong in the property and then not address that in the offer to purchase. You need to be able to deal with everything in the offer to purchase so that there's clarity. A latent defect, on the other hand, is a fault that you would not readily be revealed to you by a reasonable inspection of the property when it's being sold. And if the seller is aware of the defect and did not disclose this, the seller would be liable. For example, cracked tiles on a roof or a problem with the foundations, which I've already discussed. That picture shows you an issue with piping, and you can see the rust on the metal. That is a glaring problem, and it would be noted that that is a patent defect. You can see it. And so your estate agent needs to deal with that with the seller in the offer to your satisfaction. Now, if you as a buyer buy a property and you find that there's something wrong with the property after transfer and you're looking for the seller to compensate you in any way, you will have a hard time proving that you are entitled to compensation, because you must prove not only that the seller knew about the latent defect and did not disclose it to you, but also that he or she deliberately concealed it with the intention to defraud you. So we've had a situation in the past where there was a concrete wall dividing two properties, and the roots of the neighbor's tree had uprooted a section of that wall. The seller never disclosed anything about issues with the neighbor regarding the wall and the fixing of the wall because of the tree. And transfer happened and went into the buyer's name. And after a short while, the neighbor said to the new buyer, I want you to compensate me for the repairs to the wall, which the seller was going to do, but as the new owner now, you must do it. And I've been in a legal court case with the previous seller, and I want the wall fixed. So a whole story ensued about the wall, and the current owner got an affidavit from the neighbor to say that he was in legal battles with the previous seller, and it ended up that the current buyer could then, with that affidavit, prove that the seller had been in litigation with regards to the neighbor, and therefore the current buyer was able to be compensated, and the neighbor got his wall fixed at the previous seller's expense. Just everybody who's tuned in, if you've got any questions, we can look at them at the end of the session. I'm very happy to do that. So just save your questions for the end, please. Now, in most offers, you'll also see not only the Firzt clause, but also the Consumer Protection Act clause. A property developer cannot exclude any liability for defects in the property by way of a Firzt clause in their sales agreement, as they are covered by the Consumer Protection Act. So any issues the developer has to fix, usually when you buy into a new development, you get X amount of time for snagging, usually a month after moving in. And then in terms of the roof, the contract will usually state that after the first rains, any leaks need to be reported to the developer. The disclosure document, which we discussed earlier, is a record of all information and defects of the property which the seller is aware, and can be incorporated into the offer to purchase as an annexure. At first, we train our agents to always include the disclosure document, unless they did not get one, in the event that the property was rented and the seller is unable to disclose. So when the property practitioner's bill becomes enforced into law in South Africa, we will then be forced to include the disclosure document into the offers. But Firzt has been doing this for a number of years already, and our disclosure document is a comprehensive document that covers 3 pages of questions, wherein we ask the current owner a host of different questions relating to the property, the security, the fixtures and fittings in it, anything that's excluded, that is not staying with the property, anything that might be included, for example, pot plants and curtains, and just a very nice test in terms of disclosing fixtures and fittings. If you can turn the house upside down and a mirror falls off, it's not seen to be a fixture. If everything is bolted into the walls, then those are fixtures and fittings. There are always exceptions, though, to that rule. So again, you need to be guided by your consummate property professional, because some bathroom mirrors may wish to leave with the seller when they go, and that needs to be disclosed to you as a buyer. And certain TV brackets are bolted into the wall, but the seller might want to keep that bracket to house his wall-mounted TV when he leaves the property. It will then be for that seller to make good the wall and to advise the agent that it is his intention to remove that bracket from the wall. So in the years of our operation as Firzt, we've obviously seen a lot of different things happening in terms of offers, And the biggest thing that we've seen happening is disagreement over moving in dates and fixtures and fittings, those being the two key things that tend to get people hot under the collar. And chandeliers, and that's why we've put the picture of the chandeliers in the presentation, just to highlight to you that sometimes people get married and they get a gift from a parent, for example, of a beautiful chandelier. The chandelier's in the house and the seller forgets to tell you that that's the family heirloom and they got it as a wedding gift and they are intending to take it with them to mount up in their new home. This sort of information is something that must be discussed when the agent takes the mandate to sell that property, and certainly needs to be disclosed to you as a buyer. You cannot expect something that is going to be removed to be there if the seller's disclosed to us and we've told you that that will be removed. Just something for you to be aware of. Another thing that sometimes is not considered is the fact that buyers need to budget for additional costs. This can be for the DSTV and aerial installations. It could be for fiber. You might be used to working on fiber, and not all properties are fiber ready yet. You may have to pay for that yourself. Another one is moving costs, not to mention if you want to repaint or redecorate. But the traditional costs are the usual transfer duty fees, and anything over R1 million will attract transfer duty fee. There will always be conveyancing fees, and if you are taking a bond, you will have bond registration fees as well. There's so much that one can discuss regarding fees and costs, but those are really the basics, and you just need to know that you need to have cash readily available, because besides fulfilling the requirements of the offer to purchase in terms of contractual capacity, and what I mean by that is you need to be able to pay the deposit by the date in the offer to purchase, not 2 days later. That's not what one is looking for in terms of compliance, on the date that it's mentioned in the offer, as well as if you need to get a bond in a certain period of time, you need to have performance executed so that your bank or the bond originator that you're using can actually deliver that bond as an approval in principle to us and to you so that you can accept it. And you need to comply with the timelines. Just some points on the side that I felt important to mention. The attorneys will push for the full purchase price to be forwarded to them from the attorneys, the bond attorneys, for the guarantees to be met, and thereby the full purchase price on the property is achieved. But then, as we said, you need to have those additional amounts available to pay to the transferring attorneys as and when they request that payment for you for those transfer duty costs and other conveyancing and bond costs. Now, there are so many real estate companies out there that you might choose to work with, and that's your prerogative. All we can say is work with people that you like and trust. It doesn't matter who you do business with, might be with your mortgage advisor, your conveyancer, or your town planner. You need to work with people that are representing a reputable company and that have a good track record and are not going to disappear overnight. I'm sure a lot of you have watched Carte Blanche in the past and seen stories how builders have run away with clients' money when they were tasked to rebuild something for a client, or pool companies that took a deposit of 50% and then ran away with that 50% and never built the pool. Sometimes they would start and do a small hole, and then the poor client is left with this hole in his garden and no money and no pool. So reputable company and people that you like and trust is very, very important. I went into the detail of what a legally binding offer is at the beginning of the seminar, just so that you have an understanding of the fact that it is a legally binding contract the minute you sign it.
No.
Now, you cannot just go about with estate agents and put in offers and buy properties without full legal intention to comply. Naturally, if you've got lots of money, you can go and buy 10 properties if you can afford to pay for them all and meet those contractual obligations. But one thing you cannot do is change your mind after signing. Transfer of immovable property is governed and regulated by legislation in order to protect all the parties to the transaction. Both the buyer and the seller can be compelled to fulfill their obligations and cannot cancel the sale unilaterally. That's when it starts to get messy and the attorneys get involved and it's not pleasant. So it's simple, guys. Before you decide to buy, make sure you've looked at the house, dealt with all the issues, and only put pen to paper when you are happy with the contract. Remember that it's not an estate agent's job to make unilateral decisions about contractual capacity to offers.
Pardon?
They only facilitate the agreement. So estate agents cannot make decisions on behalf of sellers and buyers. They would need to go back to buyers.
I'm on a seminar.
Sorry, I'm just going to
be on at 7.
Mute this because I don't know. Can everybody hear me now? I hope so. Estate agents will facilitate the agreement, but they will not be able to make decisions about moving out dates, etc., without consultation with the seller, and vice versa, to discuss any needs that the buyer may have. So we've come to the end of the seminar, and we've kept it short and concise so that you can absorb as much as possible. You can email us at info@firzt.co.za, and I'd like to stop screen sharing now so that I can see the screen, so that we can do some fielding of any questions that anybody might have. Please, if you want to ask a question, unmute yourself. Okay, so I don't have any questions in the chat box, and